And let me add to you, we have incorporated in our law the Juvenile Justice Care and Protection of Children Act after we signed the Convention on the Rights of the Child. What is the best interest of the child? It's a beautiful definition. We have picked it up from the Convention. It says the best interest of the child means the basis for any decision taken regarding the child to ensure fulfillment of his or her basic rights and needs, identity, social well-being, and physical, emotional, and intellectual development. I don't think you need to look at law to look at the best interest of the child. I think the judge holds a scale and he balances the best interests with all these weights and measures. So in this perspective, now Marilyn, how are the views of the child dealt with by courts in the European jurisdiction, in interparental child removal matters under the Hague Convention, and in the development of a child-centric jurisprudence? Is the voice of the child now finding more significance, and is there an increasing trend to give more weight to the views of the child? What is your opinion?
Well, again, under the 1980 Hague Convention, the views of the child do not need to be sought. There's no provision which requires the court to seek the views of the child, who is of course the subject of these proceedings, about what he or she wants, or what she or he has experienced. The only provision in the Convention which addresses the views of the child in a broad sense is again under Article 13, which allows a child not to be returned if the child has reached an age and degree of understanding at which it is appropriate to take account of the child's views, and the child objects to being returned. So it's not a question of finding out the child's views, it's a question of finding out whether the child objects to being returned. And then the question is, what is an objection? What does it mean? And there's different jurisprudence about what an objection means. Does it mean something with felt with great conviction and where there's compelling evidence? Is that a gloss on the terms of the Convention? So, as we heard, there are 99 state parties to the Convention, 99 different countries. There's no overarching authority who administers the Convention, so it is left to the domestic law of each individual country to work this out for themselves, what it means at Convention.
So this is a judicial innovation, in a way.
Yes, it is.
It's the discretion of the judge.
It is.
And what age is considered?
And that's a really, really good question.
Intelligible age to form of preference,
But
as it is said in India.
who it's subjective. So some courts, for example in Germany, will routinely interview children, and of course that we know that what that means is going to depend on the age of the child. But the judges will see children from 3 years old. There are other countries, other courts, who will not consider seeing a child, and what does seeing a child mean, until the child is 10 or 11. The Hague Convention ceases to apply when a child is 16. So on the child's 16th birthday, it ceases to apply. So at what stage, how near to 16 do you have to be considered to be of an age and degree of maturity at which it's appropriate to take account of the child's view? And the answer to that is it will depend. Very much it will depend.
And ironically, with the so-called child reform, the age of the child, which used to be 9 when it was heard, now even at the age of 14 it actually goes down. The child is no longer heard. 14-year-old twins in Frankfurt didn't want to see their father, but were then sent into a children's
So which
home.
country?
Germany.
Yes, in Germany.
Which is particularly notorious,
Yes.
I'm afraid to say.
Yes.
With the child reform, which was
Yes.
came into being over the last 10 to 15
Yes.
years, which was more or less a father's rights reform, rather than, in the
Right.
name of children, it was
Yeah.
the father's rights reform.
So again, it is going to depend. And coming back to Anil's question, how do you ascertain the views of the child? There is no obligation on the court to find out. There's no obligation on the court to say, just a moment, excuse me, what is Susan saying about this? Let's hear from Susan. There's no obligation to do that.
There's no mandate, it's a discretion.
It's a discretion. And if I can just take one more minute to say that recently I undertook a research project with a colleague in New Zealand, and we were looking at the outcomes for objecting children under the 1980 Hague Convention. We were looking at what happens when children do object and they are sent back, or where children do object and they're not sent back. And this was a British Academy funded project. And we found one of the most interesting things was how many people, how many categories of people there are who undertake these interviews with children, from the judge to a social worker to a lawyer to a mental health professional. I think we found something like 19 or 20 different categories of people. And that doesn't particularly matter. What matters is what training they have and what consistency they have in the approach and the questions they're asking. So that diversity is enormous. So it could be hearing, yes, we're hearing the child, but what does that actually mean? And what happens afterwards? So
you need a psychologist, you need a specialist, you need evaluation, you need an expert report.
Yes, in some way.
Sorry, can I just mention that there has been a study showing the dependency of judges and court-appointed psychiatrists, in the sense of to what extent psychiatrists are manipulated in order to write certain testimonies to just ensure the judges kind of, and there have been, notorious cases where, non-experts can only say, it's absurd. In England, mother burnt her toast and she was regarded as an unfit mother. In Austria, the judge said, the psychiatrist said, a dog was sitting on the mother's lap. She's clearly not normal. A Cambridge graduate was considered by an Austrian psychiatrist as someone with no cognitive skill. I'm sorry. What is going on at the moment? It's insane.
Professor, let's look at it in a broader perspective. This is an uncharted area. It's yet finding shores. As Professor Marilyn put it, there is no judicial mandate, there is no legislative sanction for the voice of the child. It's something which the judge feels he needs to do to decide on custody. I'll give you an illustration. In India, under the Guardian and Wards Act 1890, it says, if the child is old enough to form an intelligible preference, the court shall ascertain the views of the child. It's a discretion. And I have seen n number of judgments in Indian courts where the child is taken in chambers by the judge in confidence, made comfortable, and the child says, I don't want to go. The judges refuse. There have been cases where children have parted. One child is gone with one parent and the other child is gone with another parent. So it's not a fixed view or a fixed perception. It varies country to country and judge to judge. In India, we appoint lawyers or people who have trained in mediation to give views of the child, and they're given in seal cover. So it's not a fixed pattern. It may vary in a jurisdiction. There may be a bias or there may be a swing in particular direction, but I think no hard and fast rule can be laid down as well.
No hard and fast rules. We have, we already heard a reference to Baroness Hale. Baroness Hale is the president of the Supreme Court of the United Kingdom. And in a very important case called Reedy, which was a House of Lords case, it was called the House of Lords before it became the Supreme Court. In a very important, a seminal case, she made it very clear that in cases under the 1980 Hague Convention, whether they were governed by what we call the Brussels II revised regulation, which applies, as you know, to the European Union, which we may not be members of for too much longer, but for the moment we are. And she made it very clear that children should be heard. and they should be heard. And they're not necessarily, what they say will not necessarily be followed by the court. She said that everybody who has ever dealt with a child knows that you ask a child what they want for tea, you don't necessarily give them what they want for tea, but you ask the child. It's respectful. Article 12 of the UNCRC, the child has a right to be heard, and that was the conclusion that we came to from this research project, that children must be heard. If what they're saying does not amount to an objection, then the court may not exercise their discretion in favour of not returning the child. But at least the child knows that she has been heard she is the subject of this matter. Not just the object in the sentence, she's the subject of this matter. And so we would argue, and we have argued, that children must be heard. And we think that argument actually has been won. And now the question is, when, how, and by whom? And that's where we think that the work has to be done. I'm sorry if I digress.
Thank you, Marilyn. That was a grey area jurisprudence. Maybe in another 5 years. So, ma'am, we have enough food for thought to carry on with the voice of the child. So now, friends, we have to balance the topic also. We can't tilt too much on the voice of the child, like on all issues. So let's come back to domestic violence. Now, MaryKay, I would like to know, how do you think India joining the convention will help Indian parents involved in domestic disputes in the United States? Because the numbers are pretty high. And your perspective, irrespective of whoever says, is still very important.
Well, first of all, when a family is in crisis, when there is a dispute between between parents of custody of children, that's a terrible situation for both parents, it's a terrible situation for children. And if you just remove the international aspect out of it, I don't know how many people in this room know people who have had custody issues where a relationship breaks up, there are children involved. I know from some personal experience, my sister-in-law married, before she married my brother, divorced her husband, and it was no domestic violence. It was a difficult situation. There was a lovely daughter involved, and my brother then became the stepfather of this girl, and there was a very complicated arrangement. They're both in New York City. Both parents are professionals. Both have good salaries. My brother also, when he married, has a good salary. So it's not about finances, it's not about domestic violence. It still was very acrimonious between parents over custody of that child. No international issues. So she
totally
was
domestic.
So purely domestic. So for a number of she was 3 days with the father, and then 2 days with the mother, then back to 4 days with the father. It was very complex. She had a room in each place. But my point is, and what I'm going to, the rules of the game were clear. It was New York jurisdiction. It may have been complicated. It wasn't easy for the parents. It wasn't, they both loved that child. There was a bedroom for her at each parent's place. It was difficult. How the Hague Convention will help is a long way of getting to my point, is that it sets the rules of the game. There's no jurisdiction shopping. That one parent can't take the child and run to New Jersey or run to Massachusetts where they think the state that they might have a better situation.
No foreign shopping.
Right, no jurisdiction shopping, and no. So what that means is it's very clear. It's the habitual residence of the child that determines the jurisdiction, so that both parents. It doesn't make the split easier. It doesn't make the custody.
Rules on what is the habitual residence?
Well, it's the Hague Convention sets that standard. So
yes,
but the domestic law defines the parameters of habitual residence, I guess, and Molly would be able to develop.
But I think it's roughly, you were talking about, it's roughly 6 months oftentimes. And
no, not
it
anymore.
varies from state to state. I think Molly would be the best
But
person
in
to
any
answer
case, but whatever, it's the same for both parents. So wherever they've been living, and it would also apply here. Now remember, I've talked about India-U.S. relations and how strong those bonds are, and how many Indians, well, we have 186,000, and soon I think we're going to announce soon, those numbers have gone up. 186,000 students, Indian students, studying in the United States today. And I expect it'll be more when they come out with the new statistics next week. Those students then form relationships. Some of them, they marry other Indians, not necessarily Americans, maybe no U.S. passport involved, but a child is born, the child has the US passport, they may be coming back and working in Bangalore. The habitual residence is here. One parent, could be the father, meets somebody, has an affair, rushes off to the United States, takes the kid. That habitual residence is here. So what they know is that you can't game it by going to Japan or going to Venezuela or going somewhere else hoping you've got a better deal. You know, if the countries are involved with the Hague, that the habitual residence will preside, and you know where you've been living, so therefore you know what the court system. Now, that doesn't make the conflicting feelings and the difficulties easier. It doesn't solve the relationship with the parents and the child, but it sets the rules of the game more clearly than would be without it. And that's the benefit of joining the Hague, in my view.
Sorry to say, but it's more complicated than that. There is jobs involved, and there is the type of quality of parenthood involved. Maybe sometimes someone is only an artificial father, but
Well,
not even
there's
involved.
no doubt
And
that
if
these are
someone is an
complicated cases
academic,
with what we've talked about. I mean, there's no, every single case is different. Every parent has, every motivation is different. And we have regulations in the Hague, 13B, that cover domestic violence. We can't sit here and adjudicate every single case. That's what the courts are doing. But what Hague does is say the court and the habitual residents will make those calls. It won't be an easy decision.
I know.
But that determines the court that will have jurisdiction.
Thank you. Molly, now something which Marilyn talked of in the UK perspective. Now, what, according to you, is the interpretation of the American courts of grave risk of harm to a spouse or a child, and does it include domestic violence? Now,
I think you just asked me that.
what is the interpretation of the American courts of the grave risk of harm to a spouse or a child, and does it include domestic violence?
Right, I think we just discussed this when I answered the question saying that there is no actual exception for domestic violence.
So now
but
let's
circuit
develop it a little further. What is the sort of legal aid or support? Because MaryKay talked of shelters, but now where is legal aid or financial support for domestic violence survivors in US? Now this
So-
is something practitioner
Yes.
on ground level would be able to explain.
Right, so, you know, before I became a private practicing lawyer in a law firm, I worked for legal aid for 3 years because I wanted to go to court the day I started practice. And they don't have the resources to have you shadow a partner and say, in the afternoon, you've got an order of protection, go handle it, right? So, not only are there a lot of legal aid provisions in terms of legal aid agencies. Chicago has the Legal Assistance Foundation, Chicago Volunteer Society for Legal Aid. We've got all kinds. We've got specific ones for domestic violence, like Lifespan. In courts, we have court advocates for domestic violence victims who are not attorneys, but essentially like have a knowledge of the domestic violence statute and help that person emotionally get through that court process of
So are they
testifying.
government officials or are they private
They are
people?
every county hires advocates for domestic violence
Okay.
in every county court.
And who are they accessible to? Or and for what fee?
Often they are free.
The pre bono.
They are free, and they are usually accessible to what we call pro se clients, that are clients without lawyers often.
Okay. And would that include people of all nationalities or only
Yeah,
US
so
nationals?
nationality is certainly not the issue,
Not the
nor is, by the way, being whether you are undocumented or not, to be very clear. You could be an undocumented person and receive the exact same amount of legal aid.
I mean, for our understanding, what is undocumented?
What I mean is you may not be legally within the United States.
So
You may.
your immigration status.
Exactly. Your immigration status may be that you are not legally in the United States, and you will still have access to the same legal aid. In fact, it is illegal for legal aid agencies to ask if the person is documented or undocumented. So it is not only a resource, but there are some things that I don't think are, they have an India connection very interestingly. I don't think they're very well known. For example, there's the Violence Against Women's Act, which is a federal act, which allows women who are dependent on their spouses for legal status, that is for immigration status, their citizen or green card spouses for legal status, they may self-petition for citizenship. based on the fact if they can show their marriage was in A, good faith, and B, there was actual domestic violence. This is a federal act. They do have to show that their marriage was in good faith. Often if they have a child, that's pretty good faith. I mean, that usually is not a sham marriage. Obviously a lease in common, living together, bank account, all the usual stuff to show that it was a good faith marriage. They may self-petition because one of the greatest forms of abuse, of course, occurs when the spouse is dependent for immigration status. So this is a carve-out exception, and it's pretty rare that it exists in the United States. The other thing I want to say is, and I actually once wrote a very long law review article about this, which is in the United States, and this has the India connection, because it is Indian women who created this case law and, by the way, represented themselves.
Indian spouses created.
Yes, and by the way, represented themselves all the way to the appellate court and then the Supreme Court of New Jersey, where they argued that when a spouse filed immigration papers for me, they signed an affidavit of financial support that went beyond maintenance or spousal support. That is, in short-term marriages, usually spousal support is also short-term, arguably because your lifestyle hasn't changed much in 3 years or 2 years or 4 years. So under state statutes, your alimony, what we used to call alimony, is very short. But in fact, if the husband or wife has filed an affidavit of support with the USCIS, United States Citizenship and Immigration Service, that is considered to now be a legally binding contract enforceable mandatorily by the family court judge for longer term maintenance, including until that person may become a citizen or have a certain income of their own. So in fact, there are a lot of financial resources available to an immigrant spouse, much more than actually a woman from the United States in a short-term marriage.
Excellent. I think you've done it well, very well. Molly, while you're at it, this question will bother me. Suppose there is a child born through surrogacy, and the mother is not the natural mother. What would be the rights?
So it depends on...
Can the father say she's not entitled to custody?
No,
because she's not the natural mother? She's just a caretaker
First of all,
mother.
I think it's biological as opposed to natural. But she's a natural mother for sure. She may not be the biological mother.
Correct, exactly.
No, but let us consider two instances. One, she is the biological mother, and one, second, she is not the biological mother.
Okay, but if they have entered into a surrogacy agreement, okay, and a child is born...
Because US makes it valid.
It depends on the state.
It depends on the state.
In Illinois, certainly. In New York, absolutely not. So it is state law. Surrogacy is not a federal law. So, for example, just happening to practice in Illinois, if there's a surrogacy agreement and a child is born, we call it, it's kind of crude, we call it whether the biological mother was simply a vessel, in which case she has no genetic connection to the child because it is the parents whose genetic connection was used in her body to carry the child, in which case, if the parents have the only genetic connection, the surrogate is never even on a birth certificate. They are automatically the birth parents. If the surrogate, however, is genetically connected to the child, upon the child's birth, and there's a lot of case law about consent and how many hours she has, and 72 in some states, and 48, whatever, that mother, there will be an adoption that will simultaneously occur at the time of birth. So then the birth certificate will only list the adopted parents, obviously.
Great, excellent. That's I think a good roundup.
Yeah.
Now, I can't see Philippe. Oh. Philippe, they're talking too much about it. It's too complicated. So Philippe, now let's go away to something simpler. Now, let's see. In Europe, there are a number of institutions which are looking at alternative dispute resolution, say mediation. Now, within the Hague Convention framework, it is the central authority which explores all options. Now, what is the consensual solution which you think in the consular sense can be reached? Deholds litigation, courts, judges, lawyers, interpretations, and blah, 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 blah.
Well,
So how can you play the negotiator, the mediator?
Okay, first of all, I think there is a place for prevention, you know. And for instance, a thing we are very careful about is, you know, when parents come to request renewal of passports, for instance. Of course, in a case of a married couple, we are always really sure that both parents are okay for the renewal of the passport. It's one of the possibility of control we have. So when we exercise it as much as we can, as we know that once the parent has gone to France, for instance, we have no control anymore. So I think yes, control of passport. The second thing is to I would say request and train our residents in foreign countries to generally obey the law of the country where they are. I think it's a very important matter, especially in the modern world. I would say where people, I think it's like we have two categories of people. I would say we have the citizens of the world who are traveling a lot and they can easily get a visa, they can study there and work in another country. And then we have another part of our population, I think in most of the countries of the world, who cannot travel that easily. They are stuck in their countries and they feel very offended, when some foreign people offend the law. And so that's why I think one of our main tasks is to insist on our nationals to respect the law. Whatever it is, when you are in a foreign country, I think you have to conform with the law of that country. If not, it's better to stay in your own country. So as I say, so prevention. Well, another way of prevention is, like about India. We have 3 pending cases of abduction. 2 are from France to India, and 1 is from India to France. And as a matter of fact, the 3 Indian women involved are from Hyderabad. So, when I receive a French-Indian couple who are going to want to get married, I just ask where is the Indian woman from. And if she says Hyderabad, I would just say, wait for India to sign the convention.
Thank you, Philippe. Ladies and gentlemen, our friends, the Ambassador of Spain and MaryKay, have engagements, so they have to leave. So they will be parting company, but we'll be carrying on with the discussion. And I'm sure the other panelists will get more time, and then we'll have more interaction with the audience. Thank you very much, MaryKay, and thank you, Ambassador.
It's a very important discussion, and I'm sorry that each of us has an engagement.
Your inputs were very good, and the contribution of the Honorable Ambassador by lending his gracious presence to the book launch. We are indebted, sir. Thank you very much for coming. Grateful. So Marilyn, thank you.
Yes.
Marilyn, Europe's side gets heavier. You have a more onerous duty now to perform. So Marilyn, now, you have seen the entire world working on the convention. You have seen as an academic how good are the benefits, what are the bad sides. Now, very bluntly, do you think the benefits of the Hague Convention outweigh all factors in the best interest of children?
So, I think that one thing that we really need to understand is the harmful effects of abduction. And a lot of the work that I have done over very many years has been concerned with the impact and the effects of abduction. I did some work on the long-term effects of abduction, looking at the impact on children who were abducted through their lives, particularly through their adult lives. And It was a small, reasonably small, qualitative piece of work, but it's not the only piece of work on this topic. And it details the experiences, the lived experiences of those who were abducted as children. And generally, it makes for some difficult reading, but the effects of abduction on this particular sample, which is reflected, as I say, in other work that's done in other fields, in law and in psychology, shows that the effects of abduction have been very serious. Let me just stop for a moment and say that we don't know enough about protective abductions. We don't know enough about abductions that were undertaken against a background of violence or abuse. We don't know if the impact on the abducted child is different. And there is just, all I can say about the work that I've done is that there was just a suggestion, because there are very, very small number of cases where the background had been domestic violence, but there was a suggestion that the outcomes might be different. And more work needs to be done on this, if only we could get the funding to do it, but definitely more work needs to be done. But from what we do know, the impact and the effects are seriously detrimental. And the children, we did interview children who were still children, but we also have done work with adults abducted as children. And they say that one of the most difficult things for them is the reunification, if and when it does occur. Because everybody thinks, this is wonderful, the law's done its job, the child has been found, or the child, the Hague Convention proceedings have been heard, the child has been returned, good, wipe our hands of it, that's the end of the story. And that is not the end of the story either for the child or for the families. They encounter very many difficulties in becoming a family again and in meeting the expectations that each might have of the other. But they have almost always no support. And that's one of the issues which we've tried to highlight in the work and in the research. So does the Hague Convention outweigh all other factors? No, it doesn't outweigh all other factors, but it's a good basis. And what I've said before, and I'm saying again now, is it needs support. The Hague Convention needs support. Children need to be heard. And when children have been abducted, there needs to be support for those children, whether they are returned or whether they're not returned. Because the abduction itself, abduction connotes some secrecy. Abduction doesn't happen usually other than in secrecy. So the child will be expected, if the child knows, to keep it secret from the left behind parent. The child may not know. The child may be told that she's being taken on a holiday and it's all going to be huge fun. The child may be told that the left behind parent is no longer interested in her or has died. That happens too. So all the effects of being taken, the way that it happens, the suddenness with which it will happen, the secrecy with which it will happen, the way that the child may have to adapt during the time that the proceedings are going on, the conflict during that time, those things will all impact on the child. So even if the child is then returned, that is not going to be the end of the story. That is still going to have had enormous impact on the child. So I think the Hague Convention serves a very important and very useful purpose. I think that and I'm not alone in thinking this or saying this, that it needs support, and there are ways in which if we have more time, but there are ways in which it and which I think it needs to be done.
But Marilyn, the best interest of the child, I think if you read the convention, it is ingrained in it.
Yes, well, of course the convention is premised on the best interest
Interest in
of
the welfare.
children.
That's what the preamble says.
Of children, not necessarily this particular child, the best interest of children being served, yes, by being returned. But that's the best interest of children generally, and I would say it is in the best interest of children not to be abducted, and if they are abducted, to be returned promptly. It may not be in the best interest of this particular child, and that's where Article 13B comes into play and why it's so important.
Thank you, Marilyn. Now, before we, just one moment. I would now like to invite Mr. George Hogeman from the US Embassy to very kindly take the chair and represent the American flag and take in all the American questions.
Excellent.
Sorabjee wants to say something. Mr. Sorabjee has an intervention.
You know, one question. I mean, you all know the expression, welfare of the child, best interest of the child. But tell me, in practice, is the patriarchal attitude prevalent among the judicial enforcement authorities? Do you find it? It does happen. It's all very well to have this expression, welfare of the child, best interest of the child. But judicial enforcement authorities, do they have a patriarchal bias? I would like to know.
Yes, sir. Well, in India, we do have a bias. I mean, there is a tendency. US, this concept is now free. You have mothering fathers
And in the UK.
and in UK. It's a jurisdictional, it's a cultural issue as well. It's a societal practice.
That's what you say.
It's hopping from jurisdiction to jurisdiction. We are still having that bias. Some have got rid of it, and maybe with progression of time, sir, we will also evolve a new principle.
And
So,
the
Molly,
father's rights movement is actually again a return back to the to what you said.
Esther, speak into the mic, please, so that we can all hear your question.
Well, what we see in the West, the whole definition of what a family is, no longer the trinity consisting of mother, father, and child, but it's more like a dual system. The right of the mother towards the child and the right of the father towards the child, which is difficult. But then again, the reality is the biology, which is again the trinity that doesn't exist. So in the names of fathers' rights movements, which are particularly aggressive in Germany and Austria, we have a paternalistic society again, which is the worst situation for women in the history of emancipation, is what I would say. And all of these organizations for women, domestic violence organizations, they are useless because the father always has access to the child. I mean, the most extreme case, to give you an example, is Germany, where a father sexually abused his child, for instance, in Berlin, and he was sent to prison according to criminal law. But according to family law, the abused child was forced to visit him in prison so that the father could exercise his human right to have a family. And also, the other important thing that I should mention is this. According to the EU law, a man who rapes a woman and fathers a child has the same access to the child as a married husband that a woman voluntarily chose. And I don't know that many people are aware of this.
It's a very good input. We will come to questions for the audience. Let's finish with the panel. We'll have questions from the audience. Thank you very much, Esther, for the input. Now, Molly, there is something which Marilyn talked about. Now, the voice of the child, the view of the child. We've seen the European perspective. Now, let's see what is the American court considering on the opinion expressed by a child, and what way is it accepted by the courts in USA? Because we see clearly there is no judicial mandate, there is no legislative provision. What is the US take on this?
So you're correct, as Marilyn pointed out, and you have, that the convention itself does not bind a judge to take the opinion of the child. So nowhere in the convention does it say, and the judge shall, right? It says the judge may in case law, right? And so I think in the United States, of course, it is also discretionary, but it is much more common. So if it's an infant child, obviously it's less common. If it's a toddler, it's less common. But generally speaking, because even the domestic family law has such a place in custody battles in the United States for experts, so a guardian ad litem is appointed pretty early in a custody case where the parents disagree. This is a lawyer but the lawyer is a neutral and only represents the best interest of the child by doing a series of interviews with the child, doing home studies, etc. And if the custody dispute cannot be resolved after the recommendations of the guardian ad litem or child's representative attorney, which the court sort of considers their eyes and ears in a way, because they can't go into every interview of a parent, there's also what we call a custody evaluation, which is either by a PhD in family therapy, child development, or a psychiatrist if there are concerns of serious mental health issues in the parties or the child for that matter. Since that is so foundational in our statutes in The Hague, especially when grave risk of harm is invoked as a defense, usually a guardian ad litem is appointed by the court, and often a custody evaluation is done. Obviously, the side wanting it will have to petition for it. It's not automatic, and it is up to the judge's discretion. But judges are also very, very limited in denying this request because they defer to a child expert, partly because they don't want it on their watch that something happened and they didn't appoint an expert. So they are much more likely to appoint an expert. Obviously, if the lawyer is even more forceful about it, they generally will appoint the expert. And frankly, that is a complicated matter, as people have said even in the audience, because an expert is coming in and doing the best evaluation they can do, having the qualifications the lawyer does not have. But we remember that there are a lot of parental alienation cases as well, especially when the child has been gone for longer and longer. Or there is fear in the child about discussing the abuser. Either way, the child may be motivated to give a certain narrative out of fear or alienation. Clearly, the older the child is, the more likely the child's opinion is a consideration.
Oh, good, Marilyn. Excellent. Philippe, as usual, when it gets too boring, we need to make it light. And you are the best person because you are the best non-lawyering quality person.
Yes, sir.
So, Philippe, now let us understand. I, with my experience of 35 years of CNN and being on the Hague Committee, we are culturally different in India. For us, marriage is a sacrament, unlike Europe and the US where marriage is a contract. We don't dissolve marriages for the asking. And we try to keep the home intact. For us, shelter, foster care is extended family. So we are, let us say, the special Indian context. Now, how do you think this is difficult for foreign institutions and courts to grasp? It's a tough one.
It's a tough one, yeah. Well,
see, we are huge in numbers. We are 1.2 billion,
yeah,
but 30 million of us live in 180 countries. So we import the law. So we have parallel divorces, we have parallel custody battles. What do we do with them? It's very difficult. As an expert, I have great difficulty in explaining that what is the Hindu marriage? What is the custody? What is the custodial right, as Mr. Sorabjee said? The preference of a parent. A patriarchal or a matriarchal approach. How do you think, how difficult is this for you?
So again, to keep the connection of the child with the family. So, so that is to dispel a myth about foster care. So as far as the convention goes, again, I think we have a situation, we're here to talk about family. So there's no closer relationship than human families. And these cases all result from families falling apart. And that's a tragedy. And we've already heard about how, how difficult these cases can be, even when there is no international elements involved. All right? But at the same time, children grow up.
Absolutely.
They get older every year. And so someday, that child in the family is going to become an adult. All right? My own wife and I know how quickly our children grew up. It seemed just like that. All right? And that child's going to ask, what happened? And if the parents have still, are still at this kind of conflict with each other, either it's within one jurisdiction or it's across international jurisdictions, that child is going to ask, what happened? Maybe it was that there was one parent that was really abusive and was the source of all of the problems. But again, the child will now look and say, hey, maybe it wasn't quite the way I heard from that one parent. And so I think the parents have to realize that they're going to have to reach some kind of an agreement about this. It's going to happen when the child grows up. And so by joining the Hague, it shows parents we are going to have to talk. We're going to be in one jurisdiction. We're going to have to talk. And that's really how these cases can come to a earlier satisfactory resolution.
I think, George, you're right. Maybe if we were not to sign the convention, and we would largely to look at the bill which the committee has suggested, and then maybe move forward from that into a bilateral treaty or something, would be a step forward. As I see it, at least we are going to identify interparental child removal as some kind of a wrong. 1. 2. We will create a multidisciplinary central authority which will be a forum to receive and to send out complaints. So there will be a forum. So as of now, it's a gray area in a writ of habeas corpus or a guardianship petition. So this may be a step forward. Time will take and develop. Now, I would like to come back to Marilyn. Marilyn, now just summing up, what are the lessons learned from experiences in such matters? And do you think, without compromising in domestic violence faced by aggressive issues, how can we work this out? You have the richest experience because you are a seat of all jurisdictions.
I think there are lessons to be learned. You know that I know that many of you are familiar with this. That there are special commissions held into the operation of the 1980 Hague Convention. They take place in The Hague. The last one took place last year in October 2017. And so the matters, like the matters that we're talking about now, come up for discussion. There are the 99 state parties are invited and attend. So one of the issues that comes up, and what happens is that there are statistics which are undertaken for the consideration of the Special Commission, and they have been undertaken 4 times now by Professor Nigel Lowe, and he has looked at, together with last time with Victoria Stevens, looked at one of the issues that they've looked at is about the timing, how long it takes for Hague Convention proceedings to be heard, how long it takes for the child to be returned. And of course it varies, and of course some jurisdictions do this quite quickly, and some jurisdictions do it very, very slowly indeed. And one of the problems with very, very slowly indeed is that time runs differently for a child than it does for us as adults. And I always think, if you think back to when you were at school holidays, they went on forever, didn't they? You were never going to have to go back to school. But of course, now we think 6 weeks, I can't get it all done in 6 weeks. So time runs very differently. And once the child has been away for a year, maybe 2 years, we come back to, is it actually in the child's best interests now to be returned? What does best interest mean? Another panel. It means different things to different people, and there's lots of subjectivity involved in that. So lessons to be learned, that if a child is abducted, return should happen in most cases. There are times when it shouldn't, and that needs to be considered carefully. But where the child is going to be returned, the process has to work speedily. That's the whole premise of the Hague Convention, prompt return. It was hot pursuit. It was a method of hot pursuit. Child is taken, get the child back quickly. And in terms of what would serve the child's best interest, it would be, in most cases, a prompt return. So lessons to be learned are, yes, I think it's important to expand and to have more jurisdictions who are parties to the Hague Convention, but it's not enough just to join up. There needs to be a serious intention to commit to the ethos of the convention. And children, it needs to work so that children who are going to be returned are returned promptly. And secondly, you can't just return and wipe your hands of it. There has to be support. There has to be support for the children and for the families. And I know that resources are scarce, and I know that what I'm saying is aspirational, but I think we can be a little aspirational. And if we can't solve everything, that doesn't mean that we shouldn't try to solve something. So we need to put something in place that when children have been abducted, that there are support service specialist support services in place to help them and to help the families as well. So those are
Thank you,
two
Marilyn. I think that's a very good
important
roundup. So friends, replenishment for the body is 15 minutes away. And in those 15 minutes, we need food for thought. So we have questions. Now, kindly limit yourself to one question per person so that we can have more questions. And please keep your question brief as possible. Questions relating to America go to Molly and George. Questions pertaining to Europe go to Marilyn and Philippe. And India, I'm one-stop shop.
Introduce yourself.
So it's okay, fine.
Yeah.
Please, whoever is asking the question should spell out his name and what does he do by profession. Yes, sir.
Mr. Malhotra, my question to you only. About India.
Yes, sir.
But we in India mostly.
Identify yourself.
Sir, please identify yourself.
Dr. Sorabjee today.
Yes.
I'm a scientist. So in our system, grandparents play a very important role. I think we don't talk about grandparents. When there is separation of children, most of the time grandparents take care of them rather than any other thing. What's your opinion?
Sir, I in the beginning told you, I read literature, the rights of grandparents and family members in relation to children from a domestic and international perspective is an engaging family law issue with international case law developments. Neil Ratan Kundu versus Abhijit Kundu is a decision of the Supreme Court of 2011 where despite the family court and the High Court giving the custody of the child to the father who had been accused of murdering the mother of the child, his wife, the Supreme Court, ascertaining the wishes of the child, handed over the child to the grandparents and said he will look after the children. There it is. Sir, I am a practitioner for 35 years. If in the best interest of the child, you are able to establish before a court with legitimate, cogent evidence that a grandparent is better suited in the best interest in the welfare of the child, you will get the custody. There is no bar, sir, there is no ban. It's just a question of how you present it. It's just a question of how you bring it. If you have evidence to show that a grandparent is a better person than a parent, you will get it. India is forward on this, sir. I can give you proof of it. There is case law on it. If you can establish that the child is not going to be, it's not in the best interest of the child to be with the grandparent gets it. Yes, ma'am. Brother, please help rotate.
Yeah.
Yes, ma'am. I hope it is not pertaining to India.
It pertains to, it's just an observation,
Yes,
not a question.
very good.
I am Kiran Gupta, I am teaching in Faculty of Law, University of Delhi. I just want to make few observations, very small observations.
Ma'am, please keep them short,
Yeah,
so that we can have more people.
definitely. First of all, I would like to observe that though we have not a party to Hague Convention, but we are following the principle of best interest of the child. In every case on custody, you will see that the court decide the case on the point of what is in the best interest of the child. Though we are not party, but we are following it. Secondly, in our country, India is a multi-religious country, And there are different laws dealing with custody of the child. Like in Muslim law, the custody of the child in Sunni law, the custody of the child till 7 years with the boy is with the mother, and till puberty is with the mother, if the girl. Seven. It is 7. No, I am talking about Sunni law. In Sunni law, 7 years for boy, the custody is with the mother. Till puberty for girls, the custody is with the mother. But still, and also in Hindu law, in section 6 of Minority and Guardianship Act, the guardian is the father, and after father, mother, which is now treated as equal. Father and mother are equal guardian. But the custody of the child who is less than 5 years is generally to be given to the mother. There is a statutory provision, but the courts are not following it, just to keep in mind that the best interest lies with the custody with the father. So, even though there are laws which provide that this is the period during which the custody has to be with the mother, but still looking at the best interest of the child, the custody can be given to anybody to whom the court consider to be best for custody of the child.
Thank you, ma'am, for the excellent summary. As a teacher, I think you've done very well. Yes. Brief question. Identify yourself.
My name is Nityanand Murthy. I'm a law practitioner. I have a suggestion, sir.
Please.
To expedite the adjudication before the court of law, if the matters or the cases are sustainable, connect the judges, connect the adjudicators across the world and train them multiculturally. Cross-cultural training has to be given. The obiter dictum will be good. So it would reduce the time of adjudication and
I think you have a very valid point. The Hague network of international judges
Thank you.
is developing on that.
Grandparents. I was partly involved in a case between a UK national woman and an Indian national husband, where the woman came on holiday to India under a false pretense, subsequently died within a short period of time, and her 2 children, which the husband's brother had been trying to adopt, were then left here. Now the husband had to go back to the UK for some reason, and then was detained by British police and couldn't come back to India, and is still there because his passport has been impounded, so he can't travel. Now, in the child protection order that was given in the UK, the surviving relatives of the mother were trying to get custody of the children, who are now with the paternal uncle and grandparents. And for multiple reasons, one of which being the Indian police's refusal to work with the London Met Police in this potential murder investigation. The children have been in India for 4 years now, and then one court said it was actually in the best interest of the children to stay in India because they've learned Hindi, they're going to school, and this upheaval back to the UK after 4 years would be too traumatizing for them, even though they came here roughly age 7 and 3. So they're now about 7 and 11. Is there any case that you've been involved with? I teach human rights, I'm not familiar with the Hague Convention. So I was just wondering if there are cases that have set a precedent, or if the Hague Convention itself deals with this question, which I understand is extremely case-specific of best interest, but with regards to the grandparents and death.
Marilyn, would you like to answer that?
No, I mean, as far as the Hague Convention is concerned, there's an obligation to return the child forthwith unless more than a year has passed.
The child to have remained.
Yes, more than a year has passed between the time of the abduction and the time that the proceedings are brought. In which case, there's then a discretion, because if the child is now settled in, I'm afraid the language is its new environment. I wish it weren't, I wish it was his or her, but if the child is now settled in its new environment, there is then a discretion for the court, recognising exactly this point. When the child has been away for some considerable time, and it's set in the Hague Convention under Article 12 as where more than a year has elapsed, then it may no longer be in the child's best interest, because it's a question of whether the child is now settled in her new environment. And you're going to ask, and quite rightly, what does that mean? What is it mean? It's supposed to be a remedy of hot pursuit. And if it no longer is a remedy of hot pursuit, then other interests come into it, like the best interest of this particular child, rather than the best interest of children generally.
Just an Indian input. We had the theory of first strike coined by the Supreme Court, which has now been done away with. So, in child removal matters, the sooner you strike.
United States, it is not acceptable. Over here, in these courts, say that when the marriage is solemnized under the Hindu Marriage Act, even the Tirdev, Brahma, Vishnu, Mahesh, they cannot divorce it, they cannot break it. Because this is the judgment given by the Maharashtra as well as by this Delhi courts recently, about few days back only.
Sir, there is precedent on this. There is a Supreme Court judgment of 2011 in Narasimha Rao versus Venkata Lakshmi's case, which lays down the parameters of when a foreign divorce decree is maintainable and how is it applicable and how it is valid. I was an amicus to the Punjab and Haryana High Court in the case Rupak Rathi versus Anita Chaudhary, where we've expounded this. There is settled case law on this. It's the family courts and the Maharashtra court have just probably reiterated what has been said before. Then Section 13 of the Civil Procedure Code lays down the grounds on which a judgment of a foreign court will be accepted under Indian law. So there is statute, there is case law, and this is a developed case.
They did not accept it. Even the three bar associations.
Sir, let me tell you, the bottom line is a marriage solemnized according to Hindu law in India, as per the Supreme Court of India, can be dissolved only by a court of competent jurisdiction in India. That's the law, good, bad, sad or ugly. Until we change the view.
But what about these courts? They have refused. They are this.
Sir, it's a very grey area. This is a matter of comity of courts. This is called private international law.
Comedy of the courts. Accept it.
Next question, please. Yes, sir.
Thank you.
Kavita and Molly are.
Ambassador,
yeah, I'm finishing it.
You know Ambassador J.C. Sharma is watching you.
I know that. Remembering it in a very meaningful way. Now, my question relates to the United States.
Oh.
If I remember right, and my memory could be fading, recently there was a separation of children from their mothers in the United States, and question is, there was mention about the foster care arrangement. How did it cope with? And also, such separation, was it in violation of US law or of international law? And then what happened? Why did it happen? Because I wouldn't have associated it with the United States. Thank you.
George, you could take that question over dinner or drinks.
Yeah, I think I'll take that question after the session.
Sir, this is an de-horse parental issue. Mr. Tikku would like to ask a question.
I would like to supplement to something like that.
So you are both going to grab George.
Definitely yes.
You are not going to the
Definitely
bar
yes.
till he answers, gets over the bar on this question.
Certainly yes. I've been engaged, indulging in some of the rescue or restoration of
Mr.
children.
Tikku is a former member of the National Commission for
Where
Protection
the
of Child Rights.
CPS in some of the states in US have confiscated children as young as 4 months, 5 months, 6 months, who were on the breastfed, being breastfed by the mothers, and they were separated and sent to foster care. And of course, the problem is that unless the children are restored back to the family, within 12 months they would probably lose their identity after 18 years when they are released, which is certainly not in the best interest of the child. Number one. Number two, there seems to be some kind of a mafia working there in the CPSs in various states. Because I've had this, what he said was recent, was a twin, very young, 4 months old twins who were separated from the mother, and the parents were also arrested, saying that they were unfit parents because the hospital could not diagnose what was wrong with the child. Earlier, in case of New Jersey, I remember I finally restored the child back to the extended family in India, in Kolkata and in Rajasthan. There were few cases that I handled, but then CPS seemed to be doing something very radically wrong in confiscating children and declaring parents as unfit, especially the migrant. It's not just Indian, but other migrant families, saying that they are unfit parents.
Point taken, sir. Right now or right now?
Let me just say this. So I've been a consular officer, and I deal with visa matters and American citizen services for 30 years. And so it's a narrow window, but it is a vast window on the huge range of what human beings do. All kinds of things. You know, I think every day I come to work, there's something new. And there are certainly many, many complex cases that occur around the world. And you can take certain facts from them and present it in a way, but you know, the whole picture is often much, much, much more complicated. And so I think that does play into what we're talking about here, because the issue here, when one parent unilaterally takes a child to a new jurisdiction, the other parent may not get access in the same way to that court. And so it really is impossible, or much harder, for any one court to see the whole picture. And so, yes, there are lots of examples. Certainly, as human beings, we're all human beings. Governments are made of human beings. We're all fallible. Governments make mistakes. So, you know, we hear of injustices and things and so forth. But again, it's hard for me, and I'm not going to try to pass judgment on specific cases of this kind, of the whole range of things that happen when people make movements across borders. But I do think we have to hear the whole story.
Molly.
You know, I will say though, it is an incorrect statistic that foster care somehow discriminates against migrants. Actually, the people who are hit by foster care the most are those who live in poverty, because they sometimes do not have the resources to parent in the ways that people think are how someone should parent. A lot of these people also have problems of addictions, etc., that are also related to poverty. So it is absolutely not correct that somehow immigrants or migrants are the most affected by foster care. So the other thing I would like to point out, because Marilyn had talked about the well-settled exception, I think that's Article 12, you can correct me, Marilyn, if it's not. Good. But as Marilyn said, it only comes into play in terms, at least per the Hague, if the case hasn't been brought for over a year, and then it's discretionary. I will say the most famous case that some of us might know, well, the U.S. knows about very well, is the Sean Goldman case, because Sean Goldman was taken to Brazil by his mother. His mother subsequently died in Brazil. He was not returned. The case went all the way up to the Supreme Court, state Supreme Court, where the stepfather was a family law attorney and very influential in the courts. It is one of the few cases where the state Supreme Court was forced to relinquish its jurisdiction to the federal court. And then the child was returned because the grandparents of the passed away mother were asking for custody of the child. And the court applied the well-settled exception, Article 12, even though that child the proceedings had commenced well before the year had passed. So it really can be so interpreted by different countries in terms of compliance alone with the Hague. So we have to be kind of very careful of the fact that if Brazil is a signatory to the Hague, was when the Sean Goldman case occurred, and yet applied Article 12 quite arbitrarily until it fell in the hands of federal court. So it's a rather complicated thing. I will say in the United States, we have very limited grandparents' rights. And they are dependent on grandparents have very little what we call in the legal world standing to come to court against a parent's wishes. There are exceptions, but they're few.
Thank you, Molly. Now, friends, Mr. Sorabjee is pulling rank. He says, I am not having cold food. I want hot food. The support services are saying the food is getting cold. Esther, in the break.
Secret for his continued support. He very kindly penned the fourth word for the book, although he's not physically present in this room. Yesterday evening, Marilyn ourselves had a very engaging discussion with him. He's injured his ankle, but he could not make it this evening. And of course, we are very grateful to Mrs. and Mr. Sorabjee for all their valuable support, and Mr. Sorabjee has been here. Then followed by Mary Carlson, George, the man on the ground, who is always pushing this issue, and one person who had to travel a bit to be here with us this evening is Marilyn.
And of course,
And Marilyn still hasn't got a luggage.
yeah.
No, she
Yeah.
got
You have got it. Right. And Philippe has made a wonderful contribution despite being a non-lawyer. I would imagine these are the occupational hazards of
A
being,
very good role.
a diplomat. And of course, Molly, she is very incisive and plays a very meaningful role all the time. And Mrs. Kavita Sharma has very graciously and eloquently carried on the baton of the rich legacy respect left behind by respected Ambassador J.C. Sharma. This evening is a remembrance for all the hard work and a token of for him for contributing to the jurisprudence of the diaspora and many more other issues. And of course, I will be failing in my duty if we do not acknowledge the large number of council officers and diplomats from so many missions, our dear friends of respected J.C. Sharma, law students, teachers, and everybody who has contributed to the success of this evening. And I'm sure we all can hear rumbling stomachs. Thank you so much and have a good evening. Bye-bye.
Where is Trump? Donald Trump made us solve all these issues.
Ladies and gentlemen, please join us for dinner.